I set the wheels in motion for this some time ago, and then of course we had the deferred election, so we put this off, and I was horrified that we might just have 3 people sitting in the front row and us looking very embarrassed. So I'm very, very pleased to see so many here. Fairly obviously, we're here to talk about the End of Life Choice Act of 2019, and just to introduce myself, Barry Allan, Associate Professor. I am not an expert in this area, but I have a great interest in it, and I'm pleased to be able to bring 2 of my colleagues together who do have the expertise that I think is necessary for a session like this. So, Professor Colin Gavaghan, who you've already identified as not a local of these parts, he teaches criminal law. He's got a long experience in medical law and emerging technology, and as far as I can tell, he first wrote about end-of-life decisions back in 2008. Would that be right, Colin?
Probably a bit before that, but yeah.
Okay, a long history. Okay, and Dr. Jeanne Snelling, now she's jointly employed by the law faculty and by the bioethics centre, and Jeanne teaches law and medicine and bioethics, and so they've both got history and expertise in the areas that we'll be talking about today. My email is there, mainly for the people who are watching on live stream. Hello, because I'm thinking we're going to have a Q&A at the end. If you want to send me a question while you're watching, I've got my laptop here, thought ahead, and so I'll be able to look for emails in about an hour to see if anyone at the live stream has sent in a question while we've been discussing the End of Life Choice Act. Excuse me. So just to kick things off, the legislation is being voted on at the referendum on the 17th of October, and at its essence we're being asked, do we support this idea of assisted dying? And that's defined in the proposed legislation as having a doctor or nurse administer a form of medication that will hasten someone's death to avoid terrible suffering, or possibly providing that medication to the person to administer to themselves. Okay, now it has not come out of nowhere, and Jeanne is going to tell us about a bit of the history, and we have a slide.
Thank you. So I'd like to just check first that you can hear me at the back. Great. So I'd like to thank Barry for organising this talk. When he first suggested it, I thought I wasn't sure if that many people would turn up, because it seems like we've been doing these talks for a while and people seem to be relatively well informed, but that may not be the case. So every opportunity we can get to talk about this, I'm really grateful for. So my objective today is just to provide some background information about the law, along with Colin, but I want to acknowledge before I start that it's an area that can be quite challenging, and it can be emotive for people. It can trigger feelings from past experiences, and I just want to acknowledge that some people may feel very uncomfortable that this type of law might become a reality in New Zealand, and equally there can be some people who will be feeling very concerned that this type of law may not become a reality in New Zealand. And then there'll be some people who are not committed yet to a position. My hope in this talk is not to try to persuade anyone of a particular view, but just provide some information about what is in the Act that we're talking about and what's not in the Act. But to start that off, I think it's worth having some appreciation for the background context that has been occurring over the last couple of decades in this area. This isn't something that has sort of come out of the blue, but it's an issue that's been talked about for quite a while, and it has actually been subject to 2 attempts to introduce legislation in this area before. So the first attempt to introduce legislation was Michael Law's bill that he attempted to introduce back in 1995, which was called the Death with Dignity Bill, which was unsuccessful. It didn't go past the first reading in Parliament. It didn't obtain enough support to go further. That was followed up in 2003 by Peter Brown's Death with Dignity Bill, and that had a similar fate in terms of not being supported sufficiently in Parliament. So at this point, the issue with the law was that if someone wanted to have assistance in dying, it was contravened by the Crimes Act, and anyone who assists someone to die would be liable for murder. So this was the issue that Lucretia Seales was faced with when she became sick, and as a result of this legal prohibition on assisted suicide, she took a case to the High Court. So Lucretia was a very talented lawyer. She was a woman in her 30s who unfortunately was diagnosed with an inoperable brain tumour. Her view was that she couldn't be reassured by her oncologist and her medical staff that at the end of her life that she would be able to be kept comfortable. They couldn't say with 100% certainty that they could make sure that she wouldn't suffer. And she took a case to the High Court seeking a declaration. She was asking the court to interpret our Crimes Act in a way which wouldn't prohibit people like her who were competent, who were suffering from a terminal illness and would be dying quite imminently, and who felt that their lives contain unbearable suffering, would be able to have assistance in dying. And alternatively, if the court wasn't prepared to interpret the Crimes Act in a way that she sought, she asked the court to say that the current law in New Zealand was inconsistent with her rights under the Bill of Rights Act. So I don't want to go into that case, of course. It was quite a technical case. The upshot of that case was that she wasn't successful. The Crimes Act provisions that her legal team were trying to convince the court should be reinterpreted were not, in the judge's view, able to be subject to that interpretation, and he said any law change was up to Parliament. What I want to acknowledge in this case is a couple of comments that the judge made that I think are very significant in the context of someone like Lucretia Seales, who was a very able and articulate person who worked in law reform. And one of the things that he said was that even though the law prevented Lucretia Seales from obtaining the judgment that she was seeking, he did acknowledge that her autonomy and her dignity was infringed by our current laws. So that was quite a significant admission on the part of the judge. And another important argument that was accepted by the court on the basis of evidence that was provided to it was that as a result of New Zealand's law, which prohibits physician-assisted dying, in some cases people who are fearful of suffering at the end of their lives may elect to end their lives prematurely to avoid that suffering. So counterintuitively, it meant that our law that prohibited physician-assisted dying may actually encourage and incentivise some people from taking their lives earlier because of fear that if they don't, they will suffer and won't be able to avail themselves of that assistance. Having said that, the court said ultimately it wasn't for the court in this position to interpret the law in a way, and I would potentially, not potentially, I would agree with that. I think that to open up this area in New Zealand to patients requires a really thoughtful, considered legislative approach. And so I'm pleased that we've had an opportunity to at least get some legislation as a result of that decision. I'm just going to sort of briefly outline the other sort of work that's gone on since Lucretia Seales' case was decided. And what it did do was very much put this issue back into public consciousness, and it stimulated a lot of activity. In particular, there was a petition taken to the House of Representatives by Marianne Street, who was an MP at the time, and they sought the House of Representatives to investigate the public attitudes towards this. So there was a push for some kind of public engagement exercise. That petition was referred to a Specialist Health Select Committee, which was appointed by the government, and they took 2 years hearing from people, making submissions about what they thought New Zealand should do in this area. They received more than 21,000 submissions to that committee, and they reported in 2017. 80% of the people submitting on that to the Select Committee opposed euthanasia. So they were against any legal changes. Significantly, that committee didn't make any recommendations. It really just reported what it had heard from its submissions. Before that report was actually delivered, David Seymour's members' bill had already been drawn from the ballot in Parliament, so he had already started the train in motion of actually trying to introduce legislation. Significantly, even though there were the very strong negative submissions in front of the Select Committee, we have had quite a lot of public surveys in 2015, 2016, and more recently this year. And these public surveys reflect something quite different to the number of submissions against that we've seen in Select Committee. So a 2016 survey of 15,000 New Zealanders, this was the New Zealand Attitudes and Values Study, reported that there was a majority of support in those surveyed for euthanasia, and similarly that has happened again in 2015 and in the latest Colmar-Brunton poll. And I'm just bringing that up because the submissions that are received both in the Select Committee and what we saw again in terms of the Select Committee when David Seymour's bill was working through this, the submissions received by those bodies have been incredibly negative. And again, when David Seymour's bill went through Parliament, 90% of submissions opposed the bill, and that involved about 40,000 submissions on the bill. Despite those negative submissions, we have seen this Act have its third reading, but subject to this proviso that New Zealand votes in a binding referendum. So if the referendum is upheld, if there's 51% in terms of people voting in favour of this Act will come into play and be enforced a year after the referendum vote. So that is just sort of outlining the history leading up to this referendum, and probably the number of submissions that were against these legislative attempts in the Select Committee is probably the reason that we're facing a referendum now, because political parties weren't prepared to support it in the face of such large numbers against it. So that's the background.
Thanks, Jenny. I guess the other point to make about the referendum is that if the vote is for yes, then there will be an ongoing review process as well. So after 3 years, the legislation is to be reviewed, and then successfully each 5 years after that. So the decisions being made now are going to be continuously re-examined into the future if it passes. Of course, if it doesn't pass, then maybe a political party will pick it up, but who can tell? I don't have a crystal ball that's that good. So what I want to move now into is into the heart of the legislation in terms of if it's passed, and we're assuming now that it is passed, so that we know what it is we're voting for. And the question is all about who's going to be eligible for the process that will be able to go to a doctor and say, please doctor, I'm in incredible pain, please help me, okay? So there are quite strict eligibility criteria. I'll just identify them and then I'll get my people to talk to you about them as we go through. The first point, and here our things don't quite match up, but I think it's worth pointing out that someone who is not mentally competent to make a decision will not qualify for the protection of the legislation. And the legislation says that they have to be able to understand and retain information about the nature of assisted dying and to be able to use that information in a meaningful way in the decision-making process and to communicate that decision. Okay, so if they're not at that level, then they won't be able to be protected by the legislation. We also have these people who are excluded, and I think we have to be careful here, that someone can't come to a doctor and say, I'm old, I don't want to live anymore. That by itself will not be enough. They can't come and say, I'm disabled, I want an end to things. That by itself won't be enough, okay? And similarly with mental illness. Now, there have been some concerns about this, meaning that the people who are suffering from these things, being old or disabled, can't use the Act. And I think we talked about that yesterday, Colin, so I'm hoping you can address that concern that, just because they're disabled, the concern might be, oh, well, I'm disabled, I can't use the Act at all.
The way I would describe it, Barry, is to say that these are not qualifying conditions, but neither are they disqualifying conditions. And I have seen that misrepresented in a few. It was a thing on the Science Media Centre, for instance, near the beginning of this process, where someone seemed to interpret it as meaning that the fact of being disabled or the fact of having a mental illness or being of advanced stage ruled you out. It doesn't rule you out, it just doesn't rule you in either. These are not enough to qualify, but they don't disqualify people either.
That's right. Thanks, Colin. So basically, if the elements that does qualify a person for the protection of the legislation or to be able to use the legislation, the fact that they're old or disabled won't be relevant, basically. The critical elements are first that the person who's seeking assisted dying must be suffering from a terminal illness and one which is likely to end within 6 months. And both of you could perhaps comment on how difficult that sort of assessment might be.
I think we've heard from medical people that prognostication can be really challenging, but not impossible. And I think it's not uncommon for people to be asked how long they have left, and doctors do that conscientiously. But I think there's some concern by clinicians about how accurate they can be. But I don't think if it's likely or at least possible, they don't have to be 100% accurate. It's got to be likely to cause death, and there has to be those associated factors present as well. An advanced state of irreversible decline in physical capability, and unbearable suffering as well, that the person considers can't be relieved in a manner that they consider tolerable.
And I've seen some opponents raise the possibility of miraculous recoveries while they're in hospice care, for example, as a reason for not passing this legislation.
Yeah, I mean, one thing I've learned during my involvement with this issue is that a not insubstantial number of people are admitted to hospice and then leave again because they just haven't died within a reasonable period of time. So you have to go home now, which is good news, I suppose. But I mean, it does raise this question of how precisely we can make those kind of determinations. I guess, I mean, I'm here, I should just say probably up front that I have a bit of a dog in this race. I'm on the board of Yes for Compassion, and I was an expert witness in the Seals case on the plaintiff's side. So I'm not coming to this neutrally, but today I'm here in a capacity as an academic, not an advocate, so I'm trying to be as neutral as I can. From what I've been able to ascertain from speaking to medical experts is that it is difficult. It is difficult to predict with accuracy how long people are likely to live, but also that it's a determination that has to be made in a whole bunch of medical contexts. So when a decision is made not to recommend aggressive treatment or not to tell someone that as I put it in an article recently, that their tumour or their aneurysm isn't operable, that is a value judgment. It's an imperfect judgment. We'll make it as accurate as we can, but they can't be absolutely certain about many things in medicine. So the language of the Act does specify likely, not certain, and if it specified certain, it wouldn't be realistic.
So that almost answers my next question. Could there be a better more accurate standard for this stage of the inquiry?
Well, I mean, one thing I've seen written about recently is that there could be a statutory definition of likely. I mean, does that mean more than 50%? I think for lawyers, that's language that we're reasonably familiar with, reasonably. Does it mean 51%? I mean, I think if you were to stipulate that in the legislation, that would probably be meaningless to doctors, because I don't think they would be able to quantify with that degree of granularity, even if that's what the statute required. You'd have people ticking boxes saying that, but I don't think it would mean a great deal.
I mean, essentially they're going to come to an informed judgment as to whether they qualify or not, aren't they?
I mean, that's what it is, and to me it is quite similar to the kinds of decisions that are made in these other decisions involving very critically ill people. Do we put them on palliative care only? Do we try and treat the condition aggressively? Do we decide that further curative treatment is futile? I think we have to be honest, both those who are in favour of and who are not in favour of the legislation, and say that there will always be elements of risk around this, and there will always be elements of uncertainty around this, whether or not this Act passes. That's the reality.
So if we do have someone who has come to the stage that they have reached something that's going to kill them within 6 months, and it's pretty sure that they're going to, and this legislation is not passed, where do they go? Do they just have to carry on
soldier on? It depends very much. So this legislation is not being introduced in a vacuum. There's various other pieces of law that it will have to, assuming it passes, that it will have to operate alongside, and we might talk about some of those later as well. Health Practitioners Competence Assurance Act and things like that, the Code of Rights. But there's also a substantial body of law around other kinds of end-of-life decisions. There are a number of ways in which we can make choices or exercise control over the timing and manner of our death already. Most obviously, that can involve refusal of life-prolonging treatment, and that can extend also to insisting that life-prolonging treatment be stopped. So there is case law, for example, involving people who have insisted that their ventilatory support be discontinued. Sometimes medics have felt very uncomfortable about that, but the courts have been quite clear that we as competent adults have that right, and furthermore that we have that right even if the treatment that's being offered would have a very high chance of curing us completely and offering us potentially decades more life. Paradigm example probably is the Jehovah's Witness who refuses the blood transfusion, but there are lots of others. There are people who have do not attempt resuscitation orders, cancer patients who just can't face another round of chemotherapy, and all the rest of it. So the law does recognise that we have those options. Now, for someone in this situation who might want to avail themselves of the Act, I think it would depend very much on the specifics of their situation. If they were dependent on some kind of intervention to keep them alive, they would be allowed to stop that and allowed to insist that it stops. Whether that would mean a quick death or a slower one, it would very much depend on the specifics of the situation. But some people will have, I mean, I won't say lucky enough, that's a grim way of putting it, but some people will be in a situation where exercising their current rights, Section 11 of the Bill of Rights Act, would be sufficient to achieve a fairly quick end. Others won't find themselves in that situation and won't have that option.
Okay.
I have heard at a talk that I was involved in, a palliative care doctor say that if people are denied this choice, they have the other option of just forgoing eating and drinking, and that has been put out there as an alternative to this. And there was a lot of discussion about that, but for some palliative care physicians, they would think that that was an appropriate alternative to offer someone.
Well, as you can see, I like eating, so I was wondering, I mean, that doesn't seem to me like a very practical choice, just to say I'm not going to eat and not going to drink.
I mean, people do it.
I know they do.
There was a case in Auckland not long after I came to this country, and thanks for outing me as not being local, they wouldn't have guessed otherwise. A woman called Margaret Page, who was partially paralysed and who opted to do exactly that. She just stopped eating and drinking, and her husband opposed her decision to do that. But the hospice where she was being cared for acknowledged, I think quite rightly, that legally they couldn't do anything about it. They couldn't make her eat and drink. It took about, I think, just under 2 weeks for her to die. So she must have been staying hydrated to some extent. But so yeah, I mean, it can happen. I mean, it's not going to be super quick necessarily, and it won't always comport with people's idea of dignity. It can legally be supported by palliation,
Yes.
so it needn't be painful,
Okay.
but it's unlikely to be very quick.
Cool. Thank you. And I think we can then move to the next phase, this idea that there has to be this advanced state of irreversible physical decline. What does that mean?
It suggests that they're at a point where things won't actually improve for them. It suggests to me that this could involve a person who's chosen not to avail themselves of treatment, but they're on sort of a downward slope where there's no expectation that they will improve.
So if they, for example, have a stroke and they're not on a downward slope, they just had their stroke and their prognosis is that they'll stay like that for some time, how would that sort of fit in with this standard, do you think?
I think it depends. I think in terms of terminal illness, there isn't a definition of what a terminal illness is in this. Often with strokes, people improve over 2 years after they've had that stroke, and I don't think that a stroke would necessarily come within the ambit of this Act. It says terminal illness,
Yep.
likely to end the person's life,
Yep.
and generally we're talking about things like motor neurone disease or cancer. If it was a really severe stroke, then someone is likely to die quite quickly if it's that severe.
I think that's right. A state of decline, I suppose if you could get quibbly about the language there.
Yes,
Decline
that's right.
almost suggests trajectory
We'll get
rather
worse.
than
Yeah.
stasis, doesn't it? So, but, I mean, if they're within 6 months of death, then we're expecting some change, I guess. That's not a static position.
Yep. And then I think the most difficult one to unpack, perhaps, is this idea that, and there's two elements to it, there has to be unbearable suffering, and then we look to the mechanism for relief of it, and it's the relief that the person has to not consider tolerable. So who decides whether it's unbearable suffering or not?
It's a good question. So, I mean, obviously it's subjectively determined. I mean, there's no external objective way to determine how you're feeling. We don't have a means really of doing that. But by the same token, I wouldn't interpret the law as meaning that the doctor simply has to take the patient's word for it. That would be a fairly trivial, indeed pointless requirement if that were the case. So I guess it's going to have to be a judgment that's informed both by what the patient says, what's known of the patient's condition, how the patient presents, and I think a combination of those things would be required to satisfy the doctor that there is that state of unbearable
But ultimately it's the doctor who
suffering.
makes that decision, isn't it?
Well, the doctor has to decide if the statutory criteria are satisfied, that's
Yeah.
right. I mean, you would hope it would be. I mean, people's perception of objectively similar circumstances can vary quite a lot, so you would hope that room is made for that. But I think the doctor would have to be satisfied that the situation the patient's describing kind of aligns with what is known of their condition objectively.
Jeanne? Okay? Nothing? Okay. So I think here we've got things like palliative care could be a way of perhaps preventing it from unbearable suffering. But is palliative care always going to be a solution to pain?
Well, first thing maybe to say about that is the statutory definition doesn't say pain, it says suffering. And that can involve, it's potentially a wider concept than physical pain. My understanding is that palliative care is pretty good at addressing physical pain in most cases. The second thing to say is I imagine it will normally do a very good job of managing people's symptoms, and I think it usually does. But the evidence that we've heard both in the SEALS case and in various select committees has been to the effect that there is a small cohort of just intractable cases where even the best palliative care cannot guarantee the alleviation of suffering to a tolerable level. So, I mean, there is a sense in which it could. It always has the option of just knocking the patient out completely. You know, complete sedation. For some people, that's not a tolerable alternative. They don't see that as being conducive to what they see as dignity, and essentially been left perhaps to starve to death in that state. But I suppose that is the ultimate option if all else fails. Is that anything to that?
In the other situation we were talking yesterday, that the only option might be removal of a limb, for example.
Yeah. I mean, again, this is fairly consistent with what our law says about the right to refuse medical treatments in general. You can refuse a medical treatment that would keep you alive. So it's not crossing any kind of Rubicon, I don't think, in terms of that. But that's I think where we're kind of at with the notion of palliation, that it generally good quality palliative care will do a pretty good job. And I have to say, just to be clear, the Lucretia Seale's case, at the time when Lucretia Seale's case came to the High Court, she was still hopeful that would be the case until the end for her. She'd not yet reached the point where she had said, I can't bear this any longer. She was trying to provide for a potential future situation where her suffering did become intolerable. So maybe one thing to say about the experience in Oregon and such like has been that about a third of people who are given a lethal prescription die without ever using it. Now, whether that's likely to happen under our law, given that you have to already be in a situation of unbearable suffering, is maybe a bit more questionable. But I think in terms of the law just being present on the books and being there as an option, it may just be that this gives comfort to a number of people who never end up using it at all.
And it's consistent with the idea of patients having rights, freedom of determination, isn't it?
Yeah, I mean, it's a balance, I suppose. I mean, it does go some way down that road of recognising self-autonomy and self-determination in healthcare. It doesn't go all the way down that road. If it did, we wouldn't have these qualifying criteria other than competence. You would just say that any competent adult would be able to avail themselves of this, much as they can of these other end-of-life options. But it's actually tried to strike more of a balance that factors that against risks, that takes account of things like beneficence and non-maleficence. So it's a compromise. A compromise, I think, that a lot of people aren't satisfied with on both sides. I should say there's a lot of people on the pro-euthanasia side of the debate who wanted this law to go a lot further and wanted it to extend to non-terminal situations. But a compromise is what we've ended up with.
So how does our compromise compare with those made in other countries?
To do that. You do that? Okay. Very variable. So I think there's about 10 or 11 jurisdictions internationally that have some kind of law of this nature. They differ quite a lot, both in their qualifying criteria and in terms of the kind of assistance that can be given. Some of them, so the model that we've taken is akin to places like Oregon, the state of Victoria, which have this requirement that the patient be terminally ill. Canada's still in that position for the moment, but might not be for very much longer, depending how challenged to their legislation goes. Other places like the Netherlands and Belgium, which are often held up as kind of examples of what might happen in this case, they've taken a different approach. So their approach is specifically on alleviation of suffering, intolerable suffering, and they don't have that requirement that the patient be terminally ill. So it's a variable picture across the board.
So my last question in this area is, there's talk about, this is the slippery slope. Other people say, well, this is a once in a generation sort of decision that we won't be touching this again for quite some time. Do either of you have any thoughts in that area?
Who knows?
Who knows?
I mean, Parliament's sovereign. One thing I will say is that we're in a different position from Canada. So it was only 10 days after the new legislation was introduced before it was being challenged in Canada to widen the qualifying criteria. But that was possible because the Canadian law was changed on the back of a constitutional challenge to the law before. And the tension now is, does the new act match up with what the court required? Our situation is different. Our court kind of refused to have anything to do with it and said it's a matter for Parliament. So Parliament can do what it likes. Will it revisit this issue down the line? It's just impossible to say. We don't even know what shape a future Parliament would take, what shape a future New Zealand society would take. I will say it's taken 3 years for this bill to get to this stage, and 3 parliamentary votes and 40,000 submissions to the Select Committee, so I don't think it'll sneak up on us if it happens. But the option is always there for a future Parliament. It's also there for a future Parliament to revoke this. If it doesn't go as expected, or to tighten the criteria, but there's just no way of saying.
My slides are working. Okay, so we now have a sense, I think, in terms of who's going to qualify for seeking medical assistance. But there's also a process that has to be gone through, and to some extent this process protects people, to some extent it protects doctors, I suspect. So maybe we could have a bit of a discussion about someone has decided that they can't do it anymore. What do they do?
The Act's got a provision in it that says what a doctor is required to do or is obliged to do if someone raises the issue of assisted dying. And significantly, doctors can't actually raise this issue before a patient does. So there's a provision in the Act that prohibits doctors from suggesting this as a particular option. But once a patient asks a doctor about it, they have to provide some really extensive information. They've got to talk about what that person's prognosis is for their condition. They've got to talk about how irreversible this is, so that, you know, if you choose this, you can't change your mind, that sort of thing.
Or you can change your mind, just not after the final.
After the, yeah. They've got to communicate with that person over a period of time. So the Act says they've got to communicate with that person at different intervals. So it can't be like a one-off conversation. It's almost got to be an ongoing conversation.
Well, that would depend upon the prognosis, that wouldn't it?
Yeah, it'll depend really on whether they become eligible.
Yeah.
But the sense of the Act is that this can't sort of be listening to a patient and then abandoning them to their autonomy, but rather engaging with the patient and their decision-making over time. They have to ensure that the patient knows that at any time, if they are eligible, they can change their mind. They need to encourage them to talk about it with family members, but they can't require patients to talk about it with family members, which is consistent with the rest of our approach to health law.
So just to interrupt, sorry, but it does mean, I've seen concerns raised about this, it does mean that someone could actually make this request without any contact with family members, without church, without counsellors. Absolutely. Yeah.
They can make this decision and go through the process and have assistance in dying and die without any member of their family knowing. I'm not sure how often that will happen, but there will be people who are isolated, who don't have a lot of family, who may do that. And there'll also be people who do have family who don't want to talk about it with their family because they know what their family will think. But this is the way that we treat people generally under the health law that we have. It does say that there is an obligation on providers to encourage patients to talk with people, but certainly not to require it.
And sorry, I've got confused because I'm talking about another bill tomorrow. How old do they have to be before they can qualify for this?
18.
18. And the rules talk about the attending medical practitioner. Is that their own doctor, or is it could be someone in the hospital when they've had a horrible accident? Or?
So it's whoever is managing their care. Right. So if they are a patient who's under the oncology service, it could be their consultant or it could be their GP, it could be a range of doctors. Once the doctor who has received the request, though, has given all this information, they become the attending medical practitioner and the duties and obligations under the Act kick in. Yep. So that sort of spiel that I just gave was just about the information that has to be provided at that first request. So, yes.
So what happens?
Quite specific.
Yeah. So that there's information is provided. Patient says, "I want to carry on."
Yeah.
So what's next?
So then, if the patient says, "I want to confirm and make my request official," there's the first signed form that has to be done. So there's an awful lot of bureaucracy in form filling, and I think this will put a lot of burden on doctors, because at every stage there is a form to be filled in and to be signed and to sent off to the registrar. So the patient has to sign it and say they want to proceed with this consideration of eligibility, and it gets sent to the registrar, and the medical practitioner has to witness the patient signing the form, but no one else needs to be there. Then they get the first opinion by the attending medical practitioner, who works out whether the patient's competent and meets all the eligibility criteria. And then there needs to be a second opinion by an independent medical practitioner who is also satisfied about competence and the other eligibility criteria. Either of them can say, "We don't think they're eligible," and then that has to be communicated to the patient.
So if the first doctor says no, it doesn't go any further?
No, they still need to get a second opinion, and then they'll see if they're on the same page.
Right.
If there's any concern about competence, there's a requirement to get an opinion by a psychiatrist that the patient's able to make the decision.
Are those assessments, about competence easy for a doctor to make?
The criteria for competence is that you can understand and retain the information, that you can reason through the consequences of a decision. So you need to be able to reason through the information given. You've got to have sort of that functional process. I think it's, in this situation, probably easy to understand, maybe easy to spot if someone's not competent completely,
Yep.
but there might be some grey areas. They've got to have a certain threshold that they're satisfied that the person understands the consequences, the implications, and that they've considered all of the relevant circumstances, I think.
And we're not talking about a 5-minute appointment, are we? So they're going to have a fair chance to assess.
Sorry?
It's not a 5-minute appointment, so the doctor will have
No.
a fair chance to assess, won't they?
Well, there'll be two doctors
Yeah.
ascertaining capacity with the option for a third if there's doubt.
Yeah.
Yeah.
I think a couple of things to say. One is that if they're not certain, then a psychiatrist will be brought on board to help make that determination. Is it an easy determination to make? I think there'll be some cases where it's quite easy. I think there could be some borderline cases where it's not. That's certainly, if we extrapolate from other healthcare decisions and end-of-life decisions, the ones we hear about as lawyers are the tough ones, right? It's the ones that get to court, and there are a few. There's no doubt about it. There are a few where capacity is either fluctuating or capacity is impaired in some way, and the question is whether it's so significantly impaired that the person can't make their own decisions anymore. One difference between those other decisions, though, and this is that in the kind of treatment refusal decisions, there's a presumption of capacity in our law, right 7.2 of the code. That creates a presumption of capacity. So you have to assume the patient's competent unless there's good reason to believe otherwise. Under the Act, that's not the case. Under the Act, they have to conduct an assessment of capacity. So that I'd say is probably, I mean, it won't make it any easier to make that determination, but the requirement to make the determination is an extra safeguard that you don't have in other end-of-life decisions.
So if the doctors say no, can the person shop around? Maybe there's a history of doctors who are more willing to say yes. Or does the registrar, the fact that they've kept records of this approach? Yeah. Microphone, please.
So this is what I mean by at every step there's a form that is required. So if there has been a determination already that the person's not competent, that form will be filled and the registrar will have a copy of the record.
Yeah.
So the shopping around thing is a possibility, but there would also already be a record that someone else has gone through this process.
Just to say, it can't be a one-time for all-time decision in that sense, though, because, for example, the doctor might decide you're not eligible because you're not within 6 months of death, but you might be later.
Exactly.
So there would have to be an opportunity to revisit the question at some later point in time.
Yep. Okay, so we've been to both doctors, and both doctors have to examine the person, don't they? And the psychiatric assessment is either not needed or they think this person is competent. So what happens then? They basically get the green light.
So then it's up to the patient to decide from the options what method of assisted dying they want to elect. So that can be either oral or IV ingestion of a lethal dose of medication. And they have to elect a time and a date. And this is all recorded and sent off to the registrar again. So once that's all been complied with, then they can actually check again with the patient at certain intervals whether they still want to go through it leading up to that time, and then when the time comes 24 or 48 hours before that, they write the prescription.
48, isn't it?
48 hours. At the point that the date that had been identified comes up, the doctor again has to, or the attending nurse practitioner has to remind the person that they have the choice not to go through with it. The
So-
patient, if they do decide not to go through with it, a form is sent again and the medication's taken away. Sorry?
So, was there a question? Can you shout?
So, does that mean that if the person is asked, gets the green light from two doctors, you're saying they have to specify where, and yet don't know at what point in that next 6 months they look like?
Yeah,
how
yeah.
long, there's going to be a process have to go through to city doctors, get appointments, get forms filled. How long is that going to take?
So I have to put the question onto the microphone so people elsewhere. But I'll summarise your question as being, how long does this process take? Is that,
Can we not, is it not possible to do it such that you say, this is my request, when the time comes I will let you know, but can I get it out, the paperwork out of the way now before I fail further?
and
No.
the
The-
second part of the question is whether a request can be made in advance, but with no fixed date for administration.
The forms have got to be filled exactly consistently with the requirements of the Act. And the Act says you've got to choose a date and a time within 6 months. You can't make a date after the 6 months. You've got to specify the date and time. And that has...
Could you bring it earlier if things decline more rapidly?
I wouldn't see why you couldn't change your mind around date and time. The point is that the process is incredibly strict. So the date and time is determined, then the prescription's given 48 hours before that. They have a chance to say no. If they're happy to go ahead, then the lethal medication is ingested or administered.
And right up to the time of taking it,
Yeah.
they do have the option of deferring, don't they?
Yeah. And if the person decides they don't want it, that medication has got to be sent away, removed, and another form's got to be sent into the registrar to say that they've elected to forego administration.
That's not deferring, that's cancelling.
Well, you've still gone through the process of getting your eligibility resolved,
Yeah.
so
I'm not quite ready for it just yet.
Yeah.
You have to go through another process for the next time.
Well, I think you would still remain potentially, well, you would still have to be eligible if you're deferring it further down the track. And I can't see, the only thing that could change would be if you start to decline to the point that you don't have capacity anymore.
So what the Act says is that once you've stipulated a date, when that date comes around, you can choose to receive the medication at that time, not to receive it at that time, but to receive it at a later date, not more than 6 months later, or not to receive it, but to rescind the request altogether. So those are the options. If you put it off for 6 months, I don't think that means you're starting the whole process again. You're just deferring the date. Yeah.
and I think my last question in this area is, okay, the legislation would allow someone to actually take the medication at home by themselves, perhaps, well,
At home, yes. Not
yes,
yourself.
but, yeah, sorry, for themselves, but not alone, is my question. They can have their family members around if they want to do that. What sort of medical supervision or support must there be?
Well, they can have their family there if they like, but they do need to have the attending medical practitioner or attending nurse practitioner available to them, and that's defined in the Act as either in the same room or in close proximity to the person. So this is, I guess, partly why it's important to stipulate the date and things. The doctor, it's not like Oregon where you just take the medication away and take it if you want, when you want. It has to be under medical supervision or close by.
In my understanding, we haven't worked out what the medication will be yet, is that correct?
We were speculating. We won't speculate in front of the audience if you don't mind, but no, we don't know that for sure.
Yeah. But one would hope it's going to be something which is
It should be
safe.
quite well. I don't know how you
Safe
think safe in those
safe
in
in
these
the-
circumstances, Barry,
Yeah.
but
But
it
safe in the
should be-
sense that it's a painless end and it doesn't have side effects.
Well,
and,
th-
and
I
it's
mean-
fail-proof.
you,
It's a joke.
I think you would want it to be something that would pretty much guarantee a good death, because otherwise it's going to defeat the whole point of
That's where I was
doing
going
this.
with safe, yeah. All righty, so And the last area is, I mean, we've touched upon some of the safeguards here with the need for the doctors to be involved. And the fact that the person has to initiate themselves. What sort of, because there's a lot of talk about how they might be wanting to do this because of pressures from external sources, or even a feeling that, oh, I'm a burden on society or my family or whatever. I guess first question is, what safeguards are there against that? And the second question would be, in terms of someone thinking, well, I want to put an end because I'm a burden, is that a legitimate choice for them to be making anyway?
I'll answer you the first question first. One is, there's a statutory requirement here for the doctor to check for external pressure, okay? And they would do that, according to the legislation, by consulting with other medical professionals who've had dealings with the patient, and with the patient's agreement, checking with members of their family. Now, if you think the pressure's coming from the family, of course, then you'd maybe have to want to check more widely within the family rather than just the person who comes to see them most often. So this danger of external pressure isn't unique to this situation. It's something the courts have had to deal with before around end-of-life decision-making. And occasionally it's something that does end up before the courts. Where I think this Act is unique in that it creates a statutory obligation to check for that. Again, like the capacity assessment, it's an imperfect inquiry. I don't think there's any way, there's no scientific measurement of how much pressure somebody's under. The courts have always adopted more of a rough and ready, is it undue influence? Is it such a degree of pressure that it, I mean, no decision is made in a vacuum. We're all subject to the influences of our society and our upbringing and our peers. But the courts get to a stage where they will say, this is too much. This is no longer your decision. It's a decision that's been sort of foisted upon you. But there's no, I mean, scientific weighting of that. And there never has been, and I don't see how there ever could be. But the second question you ask is one that I've wondered about a lot down the years. Is the existence of a sense of being a burden or a sense of owing a duty, is that, if I can paraphrase it that way, is that inconsistent with an exercise of autonomy? And I just don't really know the answer. But one thing I would say is that it's quite interesting that if you look at, there's some philosophers in the room, so I won't go beyond my pay grade here, but if you look at more kind of less liberal and more Kantian notions of autonomy, the idea of acting from a sense of duty isn't something of which we should be suspicious. It's something that's quite consistent with those concepts of autonomy, and would in previous generations have been seen as quite a virtuous thing to do. So I'm not sure that acting out of a sense of duty in itself is incompatible with capacity or with autonomy. But again, as with other influences on our decision making, there could come a point where it was of such a degree or such a nature that it was deemed incompatible. And I think people who are demanding a clear, bright line test for this know they're demanding the impossible. It's never been possible in any context, but there is a requirement at least to try and satisfy themselves here.
Well, I mean, if the doctor suspects pressure, what impact does that have on the process?
Well, if they suspect it's I'll try and find the exact, do you want to say
I think it's section 24.
So the Act says if a medical practitioner suspects on reasonable grounds that a person isn't expressing their wish free from pressure, they're required to take no further action, and they have to tell the person and they have to send a form into the registrar.
So it kind of, to me, sounds a bit like a fairly low bar for the doctor saying no.
Yeah, and I think when I've talked to people involved in palliative care who are feeling really uneasy about it, they always seem to picture this hypothetical of a little old lady who is dying and her family are sort of young and active, and they say you wouldn't treat a dog like this. So they're concerned about that kind of pressure, but I guess what I think with a health background is that is the situation where you'll be relying on a lot of medical people to actually advocate for that patient, and there is a provision in the Act that they can rely on and say it's not free from pressure, and we think there is coercion here.
It's also maybe worth noting that someone subjecting someone to that degree of pressure would be committing quite a serious criminal offence.
Yes.
Because Section 179 of the Crimes Act would still apply, and aiding, abetting, counselling, procuring, inciting suicide can carry up to a 14-year prison sentence. So I think anybody thinking of doing that would probably be advised, on moral grounds for one thing, but on legal self-interested grounds, to think twice about it.
Yeah. And I think we got just a little, oh, sorry, we had that on the slide. Just a little bit to end in terms of oversight. Yeah, we've got the doctors obviously, but then the doctors themselves are subject to considerable oversight.
Doctors are subject to consider. Well, there's going to be 3 new oversight mechanisms created under the Act. We've got the new registrar who will take delivery of these reports, who will check along the way that all the statutory steps have been complied with. We have the so-called, what they call the SENS group, which is the support and, what was the C stand for again? Support and consultation.
Okay.
Support and Consultation and Intelligence New Zealand Group, which will both maintain a register of doctors who can fulfil this second opinion kind of role, and also produce kind of guidelines and things. And then finally we have the review group, which is charged with, as the name would suggest, reviewing the functioning of the Act and making reports to the Minister. So there's a bunch of new oversight mechanisms, I should say, which are charged with keeping an eye on this kind of stuff. And then ultimately the Minister, him or herself, is going to have to make regular reports to Parliament on the functioning of it. And as you said right at the start, after 3 years is a mandatory review of the operation of the legislation. So there should be a fairly good sense as we go on of how it's operating, how often it's being used, how often cases are being approved. And yeah,
So it's just occurred to me, but all of this information is going to be kept private?
The personal information, the identifying information will certainly be kept private. The audit information, the facts and figures, statistics will be,
yep.
yeah, they won't be kept private.
And last slide, I think. Oh, no. And that's where the practitioner who is requested to assist someone with dying is not comfortable with helping the patient. And what ability does that doctor to say, I don't want to do this?
Oh, okay. Well, I mean, there is in this legislation, as there's been in all the proposed legislation, a provision for conscientious objection on part of any medical practitioner. And in that situation, the only obligation they will have is to inform the patient that they're conscientiously objecting, and to inform the patient further that they have a right to see a different doctor, and to tell them of the existence of the SENS group, which maintains a register of those doctors. There's no obligation to refer. There's no obligation to ensure that they are put in touch with another doctor. They can at that point say we're having no more to do with it. I would imagine good doctors at that point won't seek to abandon the patient or anything. They might still be involved with their care in other ways, but they don't need to have anything more to do with the Act.
And there's been some litigation by the hospice group.
Hospice NZ, yeah.
Yes.
It's quite an interesting case. I don't think you don't very often come across court cases about a piece of legislation that's not actually in force yet. The court at several intervals kind of said, well, that's a bit too hypothetical. We can't really say this. But what Hospice NZ in essence wanted to check was that not only could the conscientious objection clause mean that individual practitioners could exempt themselves from involvement, but an entire hospice, an entire provider could do the same. And the court said, well, not only can you avail yourself institutionally of the conscientious objection clause, you don't even need to go that far. It's entirely reasonable for the hospice to say, we just don't offer that service. You know, just like we don't offer dentistry or hairdressing or anything else, we don't offer this service. So you just won't be doing that. They can't stop, if they have health practitioners who work with them part of the time and maybe do some private practice or something else, they can't institutionally block them, but they can make sure they don't do it in the hospice, within the hospice, or while they're working for the hospice.
I think our timing's pretty good. It's now 6:30, so I've tried to ask the kind of questions I thought that you people might have, but I've probably missed some. So if people have questions, I'm sorry we don't have a microphone. The technology's not doesn't allow more than 2 microphones in the room. So you'll have to shout, and I will try to put your question into the microphone so that people at home, if there is anyone indeed watching, they can hear what the question is.
I don't mind running about. If that's
Oh, if you want to run about, he needs his exercise.
Mind it.
So right to the back, please, Colin.
It'll warm me up.
Thank you. The legislation seems to be a copy of the Abortion Act, with the way it's been prepared, the 2 doctors agreeing and so on. And it's taken about best part of 50 years to actually move the Abortion Act into a place where pregnant people have autonomy. So hopefully it won't take that long with this act to move it to a more reasonable place. But I appreciate that it was a matter of getting something past the post to get this act through. But on that, will these doctors get special payment from the Ministry of Justice or somewhere, just as the previous old Act Abortion Supervisory Committee, abortion certifiers used to get payment? What's going to be the funding model? Because there's an awful lot of time and energy to be put into this. And if you're expecting this ongoing commitment, this is not covered by the current situation. So what's been intended for funding for this?
Can I just check if anyone else up the back wants the microphone before I go back down? No? Okay. Do you want to? Oh, you've not got a microphone, sorry. I teach emerging technologies. I'm total rubbish with existing ones. We don't know. Next. No, we don't know. And the court in the High Court in the Hospice NZ case said there's an awful lot of decisions about funding which will have to be made during the year, assuming the referendum passes, the year between that and the Act coming into effect. There's a whole lot of decisions have to be made, and that includes decisions about how this will be funded. I suppose that could depend substantially on who wins the election as well, and what the funding priorities are and things of the incoming government. But no decisions, as far as I'm aware, have been made yet, and certainly not been made public yet, about how it's going to be funded.
Anyone else? There we go.
Thank you. So in most normal medical practice, your doctor offers you all the range of options that are available to you. Given that the patient has to initiate that conversation, can you see any possibility of new inequities in access created by the fact that it relies on a patient to be the person to raise it?
There's just no shortcut. Do you want to do this? You're right, Emily, that normally there is a requirement under the code to inform the patient of all the rights, all the options available to them. This is a specific statutory exception whereby the doctor cannot do that. So it will, I think you're right in a sense, it will depend on the patient being aware, and not only perhaps aware of the option, but confident enough to raise it. There's no way to, everything in this act's a compromise, and every safeguard is also an obstacle, and I don't know if there's a perfect way to do it, but it's a valid point, I think.
I think we copied the Victorian Act in terms of that provision, and I think it's really to allay concerns of suggestibility. The concerns about vulnerable people feeling a burden, and if it's brought up and put on the table, it may be something that they think they should consider that they might not alternatively have. But I think also a lot of people who are terminally ill do think about the way they're going to die and how they're going to die, and it's hard to think that kind of conversation about how am I going to die doesn't come up. And a doctor who actually might engage in a conversation around this won't be in breach of the criminal law, but they'll be in breach of the civil law. So the penalty for a doctor sort of breaching that requirement not to bring it up isn't as severe as other penalties for breach of the Act.
Thank you, Dr. Allan. Thank you, Jeanne and Colin. Really informative session. Just a couple of comments. I represent Voice for Life. That's the organization that we've got a local branch. We defend unborn children and people who are vulnerable. So just speaking a little bit on behalf of our organization today. So I guess our basic statement is, as a Christian organization, we believe that God alone can take and create life. So having stated that, Jeanne, you mentioned that they would put lots of burden on the doctors in terms of paperwork, which is interesting reviews coming, I think, from the Netherlands or Belgium, and I can't remember exactly statistics, Colin may know them. I thought it was up to 2/3 of euthanasia which was conducted over a certain period of time which did not meet requirements of the legislation in Belgium or Netherlands. So that's already really worrying in terms of legislations such as Belgian or Dutch, which are quite efficient. The other issue, I guess, Colin, you talked about, hard to predict the slippery slope. If you look at some of the developments in Belgium or the Netherlands, you could see the slippery slope happening over the last 5-10 years, with that legislation being extended out at the age of 13 or 16 in certain legislations where children of that age are eligible for euthanasia-assisted dying. The last issue, I guess, you talked a little bit, Colin, about the association of hospices being worried. For example, in Canada, I guess, lots of organizations who refuse certain procedures like abortions or euthanasia do not get government funding. Therefore, lots of organizations like here in New Zealand, they would be worried about it. The last comment is, I guess, what are your views about the relationship between the youth suicide that New Zealand is a leader in and that coming legislation, and what that might mean for young people in terms of perception of the value of human life?
I'll try and go through them backwards if I can remember. So the last point first, it's a major problem in this country. Our youth suicide, our suicide rates in general, but our youth suicide in particular is grim and has been for a long time. I don't think, like probably a lot of people in this hall, I've had close personal experience of people close to me doing that. I've never found it difficult conceptually to separate that from a terminally ill person seeking to control the manner and timing of their death. And I don't really think there's a blurred message coming out. I mean, we also, it's maybe a slightly glib point, we also want to reduce the opioid abuse, but we don't oppose the use of opioids in treating dying people. I think conceptually they can be kept distinct. The second last point, or possibly third, to do with slippery slopes. I agree with what you're saying up to a point. I mean, I think you certainly can find examples where that has happened. Okay, I think in the Netherlands and Belgium are a pretty clear case where the criteria have been expanded down the years. You can find other examples where it hasn't happened. So Oregon's had the same law in the books for 23 years and it never changed the eligibility criteria. All I can say is it would be up to us. I think it's possible. I don't think it's inevitable. I think there'd be people pushing to do it and people pushing to stop it. And I can't really predict how that'll go other than to say it's not inevitable. So it's all up for grabs. I've now forgotten what the third last point was. Do you remember?
There was the consent issues with the consent with some of the legislation where the actually consent requirements have not been met.
Oh, in the Netherlands and Belgium again. Yeah, I mean, there've been, as you'll know, there've been books and books written on the Netherlands, particularly the Netherlands, because it's the longest standing example of it. Lots of different claims about what's been happening. There certainly have been some instances I've heard of that would make me uneasy if they happened here. I won't deny that. So again, I would say our law is set up rather differently than theirs is. But there's going to have to be, what I will say is quite honestly, although I support this act and I'll be voting for it, there's going to have to be firstly a lot of discussion over the year before it comes into effect of precisely how it's going to be operationalised. And that goes to your other question as well about funding. And secondly, there's going to have to be close scrutiny of how it works once it is in operation. I would certainly say that. The funding issue is a really interesting one because if I can take the lady at the back's analogy with abortion, striking the right balance between allowing people to have protection for their genuine conscience and trying not to allow people to use that as a mechanism to block access to everybody. Do you know? And I think there have been some examples of that have looked a bit alarmingly like that you can find internationally, people who try and get themselves into positions where they can then use their conscience as, it's been said, a sword rather than a shield. So it's a tricky one to get right, you know, and there will be a lot of discussion to be had over this year with whoever the new government is about how precisely that funding thing will go. I sincerely hope, however, this doesn't mean a reduction in funding for hospice and palliative care, because that would be a disaster Okay, for those of us concerned about choice and about good quality life at the end of life, that would be an absolute disaster if this was at the expense of that.
Rex.
Can I just say too before,
Thank you, Barry.
there's also the possibility that people are suiciding out of desperation as well, and that was actually borne out in evidence in Canada and also evidence in New Zealand. So in some small sense, this might actually prevent people from suiciding if they know that they have this option. The other thing I was going to say, I counted up how many forms have got to be sent to the registrar for this process, and there's about 11. And if any of those forms aren't filled out properly, it can be a criminal offence if they're willfully not filled out. So there is that kind of level of bureaucracy, and those reports are reviewed by a committee. We'll review the whole thing in 3 years. So I think there's been significant attempts so that we don't end up in a situation where someone is euthanised without consent. I can't see it being possible, to be honest.
Well, gee, all those forms, that doesn't sound very environmentally friendly to me.
Electronic.
Anyway, Rex Arter's my name, and I'm dead against this legislation. My question is, you mentioned in passing that 51%. I don't think that's correct because, well, it doesn't say that in the Act. It simply says a majority of voters at the referendum. So if 2,000,001 are in favour of it versus 2 million against, it's going to pass. So there's no percentage figure. It's literally just the majority. Yeah. That was really just the clarifying point.
Sorry.
Thank you. My question is, would it necessarily be a bad thing if it were extended? It seems to me that in time, it seems to me that it's a very cautious act. And as you've said, so it's been the result of compromise amongst differing views. If it were found that it should be extended, I wouldn't see that as a bad thing.
It's not necessarily a bad thing.
No.
It's not necessarily a bad thing.
It could be, but
I'm one of these people that's probably not much loved on either side of this debate because together with Andrew Geddes, who was there a minute ago, we made a submission to the Select Committee suggesting that the Act should be restricted to only apply to terminally ill people. And I know a lot of people on the pro side of the argument thought that was a cop-out. I will say it was mostly Andrew's idea, and if you don't like that suggestion, it was his fault. If you do, it was mostly me. But it's not necessarily a bad thing in itself if the definitional criteria expand. If we have this for a period of time and it's operating as it's supposed to operate, and there haven't been kind of scandals and fears in it, and if the monitoring and supervision is going the way it should be, then I would be open to revisiting it. I'll be honest with you. I'd be open to looking at it again at some point in the future. I guess I'm just quite a cautious person by nature, and I think a kind of incremental, let's see if we can manage this first, and only if we can, then we can consider that possibility. But I wouldn't see ending up with a wider, from personally speaking, I wouldn't see us ending up with a wider definitional criteria as being a bad thing if I was confident it could be managed appropriately. Not everyone agrees with that, but that's where I'm with it.
I'm just wondering what the, if you could clarify the unbearable suffering. Is it, I think it's experiences, is it present, continuous, potentially in the future? Like when does the unbearable suffering have to kick in?
Why I read it as experiencing, as in now. To be eligible, you've got to be experiencing it.
So at the point of the consultation, you
Yeah,
have
at
to
the very
be
beginning.
experiencing. It's
Yeah.
not that you are anticipating that the suffering will be
So
coming.
this doesn't seem to be written like an advance directive that when it happens in the future that this will kick in. It seems, to be eligible, you've got to be experiencing it now. So like, for example, say if someone's terminally ill with a brain tumour or lots of tumours through their body, it could be that we can say, well, we'll give you radiotherapy and that will reduce your pain. But the person's saying, I'm not prepared to go through that. There is something that could actually reduce my pain, but I'm not prepared to go through more treatments. I'm experiencing unbearable suffering now, and so I want to start the process now.
I suppose, though, I mean, it's all written in the present tense, so it's suffers from a terminal illness, is in an advanced state of irreversible suffering, experiences unbearable suffering. But I would guess it probably doesn't have to mean that they're constantly in that state. There could be periods of, I guess, some relief or remission, and I don't think that would rule it out. But it has to be now, not in anticipation of a future state. I don't think I can think of any piece of legislation that is so watertight that I can't imagine a possible situation going to court. Whether that's because the terms aren't specific enough, or because a particular case arises that it's not quite clear if it fits with the criteria. So we can't rule that out. I mean, that's an important role that the courts have. Can I anticipate situations coming to light where that happens? Maybe. One thing we were talking about when we were just knocking this around the other day there was, what if someone is in a profoundly disabled state in a hospice that doesn't agree with this act, but wants to bring their own doctor into the hospice to give them assisted dying, and the hospice says, we don't do that on these premises. Now, there have been kind of analogous cases in the courts where people wanted life support switched off and the doctors didn't want to do it, and the courts have said you have to transfer their care to someone who will. But what if they're not in a physical state to be transferred from that place to another? That's one that would be quite an interesting legal question to try and pick through. But I mean, there'll be others. Oh, I don't think the criteria. I mean, it has happened in Canada, but that's because the whole law change came about through the courts. Ours has not. So I don't think there's much scope for it to be broadened or narrowed in general. The application to particular cases might have to be determined in that way.
Alistair Yule, I'm a member of Doctors Say No, so certainly I feel tonight it has been, even though presented as neutral, has been very slanted and has sounded very plausible. This is abhorrent to someone who's been in hospice care, dealing with many patients in their terminal illness, and seeking to supply good service, controlling distress in all its forms. I realise this has been put on by the law faculty, but you've tried to suggest medically this and that, and I feel that you've fallen short on some of those things. A wee question to the yes compassion vote. For one who understands, compassion means walking with, sharing with a person suffering. I wonder how you can use that term in all honesty, that this is compassionate to be assisting dying.
I guess what I would say is the important thing for me is that people have different ideas about things like compassion and things like dignity. I personally have no idea if I would ever use this law. I don't know if I would. But it's not just about that. It's not just about me, and it's not just about one person's view of what compassion means. It's a recognition that we live in a pluralistic, multicultural society where people have different values and different ideas about these things. And I just see that as a step along that road to recognising and making provision for people to make their own choices about these most important matters.
I had a different question, sorry, but Barry, do you mind if I actually reply to that from a personal experience?
Yeah, go for it.
Yep. So I lost my mother to breast cancer when I was 5 years old, and my last actual memory of her was walking into a hospice room, and she got amazing hospice care. But the last sort of few months of her life, she was in such a state that 5-year-old me didn't actually recognise her, and she could speak barely a word of actual English. She was high on morphine the whole time, just in such a state that like her own child couldn't recognise her. And for her to have to watch me go into that room and not even recognise her, to me is so abhorrent to the idea of compassion that, like, and you know, she had the chance to make her amends. She wrote diaries for me, made videos for me. She had that time. And at the end of her life, there was such little quality of life left that she agreed at the time. My father agrees, and obviously I agree, that if I or anyone I loved was in that sort of state where they'd had the chance to make their amends, considered all the options, to then force someone to live in that drugged up half life until the drugs can't cut it anymore, is abhorrent to the idea of compassion itself. And that's just, you know, it's quite an emotional story for me, but that's, I don't quite understand your argument. Like, I understand where you're coming from. I'm a Christian myself, and I understand sanctity of life, but there must become a point where living isn't life anymore, and you're keeping someone alive purely for the sake of it, or purely for ideological or religious purposes, and not because it's any kind of real or positive life that you can experience anymore. I wouldn't class being drugged up, unable to leave a bed with, you know, barely any memory and no ability to speak or express yourself, any kind of reasonable life. So, like, I understand where you're coming from, but I personally have to disagree. Although, back to my question, in terms of, you've spoken a lot about terminal illness, as in things like cancers and motor neuron disease, but would this act apply to anyone who could die within 6 months? Not necessarily of old age, because I imagine that would be very hard to project, but let's say I was in a car crash and through no illness or other cause things just weren't looking good for me. Would I have this option if it was looking likely for me to pass away within 6 months?
The Act stipulates terminal illness, which I would take to probably mean that it has to be some. I don't know if illness is defined in the interpretation section. I don't think so. We don't have a statutory definition of illness, but I would take that just in a kind of everyday reading as probably ruling out things like injury. Maybe is that how you would see it?
I mean, terminal illness could arise, say, from end-stage renal failure, things like that.
Yeah.
So it's not just cancer or motor neuron. There would be a broader thing. Yeah. I just want to sort of say something about compassion, and I don't normally talk about personal things, but I've been in a situation where I've lost 2 siblings and a father, and in one situation I had to fight incredibly hard to get doctors to actually treat my brother, who said he's terminal, he's not going to, we can't put those resources into him. And we fought very hard, and he lived for another 2 years. We were up against a very powerful medical community, and it was only because I was a nurse and my other brother was a doctor that they listened to us and they took him into intensive care and they treated him really aggressively for 2 years. I think what this is about to me is actually allowing people to be in control of their decisions. So we fought hard for him to live, and then after a couple of years he actually asked me to turn up his morphine pump, which I physically couldn't do. It was totally, I wasn't physically able to, and I actually felt like I let him down a wee bit because I felt so uncomfortable with that. But I just don't think that medical people have a monopoly on what compassion is, and I just want to clarify that.
I mean, what's as important for me is that people who don't believe in this or don't want this for themselves or don't want to have anything to do with this are not in any way coerced or tricked or fooled into doing it. I mean, that's the other side of the whole idea of end-of-life choice. So it's not just important to have these protections and measures and legislation. We have to be very careful to make sure that they're working as they're meant to, and to monitor them carefully if this comes into effect.
Time for 2 more questions.
Cool. I just want to say thank you very much for sharing your stories. It'd be really difficult to do. One question I did have, I don't know how acts are created or how they're put together, but do you know with this particular one if there was any consultation with Māori and how it's been written? And
that is a gap. This came through like a private member's bill, so there is a deficit in the Act, I believe, in terms of not having a principal section, and one of those would be making sure that our provision of services is culturally competent, and that is a gap. There has been some discussion of this in the media from people who are concerned about this from a Māori perspective, but it seems that there's no single Māori perspective on it. I know there were some MPs in Parliament who spoke against this quite strongly, who said that it wasn't consistent with tikanga. But in terms of what I've read, which is just media, it doesn't seem like there's been a single view, but I don't think that there has been a cohesive consultation as such to represent a view.
I don't think you could represent a view, but I'm not sure about whether there could have been more or better consultation with Māori. In terms of what you say about cultural competence, you're right that there's nothing specifically in the legislation. The only thing I would say is that this operates alongside the code which does require that. So any doctor discharging functions under this legislation will still be required to take account of cultural considerations, although it's not stipulated. It could have been stipulated in this Act, it wasn't, but it still exists alongside it.
Hi, I'm Sally. I'm just a common garden GP working in aged residential care, where, as you know, many folk do die in aged residential care, and just a reminder that the hospice is not a place, it's hospice extends to assisting people at home and aged residential care in many places. So my job with the dying person, I see it as very much a collaborative job. It's a constantly talking with the person who's dying and with the family. So I think that we need to have quite a lot of training, I think, for anyone involved in this legislation. I personally find it a bit foreign because of the way I currently work. And the other thing is, I think we need to take good heed of why the hospice body have come out with such a strong statement, and people like me working in the community, I involve them a lot with day-to-day care of patients. So if I don't have access to the hospice team and decision making, then it's quite a loss to me in terms of caring for many people in the community who are dying. So I'm a bit disappointed there isn't more written about training what they plan to do. Sounds to me like a big omission that they have to achieve in a year.
Yeah, I mean, there's going to be a lot of work there. The Hospice NZ case, the High Court talked a little bit about that. I said, you know, there's nothing to stop, for example, the Medical Council adding training requirements and other kinds of things in. But I think whatever happens in this referendum, the discussion doesn't stop there. There's going to have to be an awful lot more discussion about precisely how this is implemented. And if there are indeed training gaps, then to identify those and to see about how those would be met. I totally agree. It's a good point, I think, an interesting point you make about the hospice not stopping at the door of the hospice. I guess what I was meaning when I used it that way was that the court decision said that the conscientious objection could extend to the institution. Obviously, it couldn't extend to the person's home. The institution can't extend their conscientious objection to what happens in someone's private dwelling. So in that sense, it is a building, if you see what I mean. But I totally understand that in other ways you wouldn't think of it that way.
All right, it's coming up to 7, so no talk can exist without an audience. So once again, thank you very much for coming along. For those who spoke, thanks for asking questions and sharing your experiences. And of course, I hope you'll join with me in thanking my two speakers.